to deny access to information by Congress in aid of legislation. It is therefore the position of this court that if the Sandigan Bayan pursuant to its subpoena powers cannot be denied AMLC records as well as the legislature in aid of legislation, it most certainly cannot be denied to the Senate, sitting as an impeachment court. The defense also vehemently objects to the production of AMLC documents by pointing out to the agency's own printed footnotes, which restrict the reports for intelligence purposes only, quote unquote, and explicitly state they are not to be used as evidence in any formal proceedings. The court, however, overrules this objection. The admissibility and evidentiary weight of documents in an impeachment trial are determined by the Constitution, the rules of court, and the judgment of the impeachment court, not by unilateral disclaimers printed by an executive agency on its letterhead. An administrative footnote or internal intelligence sharing protocol cannot rise to the level of a constitutional or statutory exclusionary rule. While the AMLC's internal protocols are validly designed to prevent premature leaks during ongoing investigations, they cannot legally operate to tie the hands of the impeachment court once the documents are lawfully subpoenaed. Because the requested suspicious transaction reports and covered transaction reports satisfied the threshold of prima facie relevance in tracing the alleged accumulation of unexplained wealth under Article 2, they shall be produced. The defense further invokes the 5-year record retention period under the AMLA regulations. The 5-year period is a minimum mandatory retention requirement imposed on covered institutions. It is not an absolute prohibition against keeping or producing all the records. Accordingly, let AMLC invoke this limitation in its return, which this court shall take into account and inform the parties thereon accordingly, should they be unable to comply with the subpoena. As for the partnership of Carpio lawyers, Section 1 of Republic Act No. 10365, amending Section 3A7 of Republic Act No. 9160, treats as covered persons those including lawyers who manage client money or assets, manage bank savings and securities accounts, organize contributions for companies, or create, operate, or manage judicial persons or arrangements. Section 2C of AMLC Regulatory Issuance B No. 1, Series of 2018, adopted on May 10, 2018, and filed on June 13, 2018, expressly reiterates this activity-based rule. The court recognizes the statutory exception for lawyers acting as independent legal professionals, where the information concerns their clients or disclosure would compromise client confidences or the attorney-client relationship. Absent any showing, however, that the particular record sought contained such information or would compromise a protected confidence, the exception cannot be invoked merely because the entity concerned is a law partnership. It protects client confidences. It does not confer a blanket immunity upon every financial record bearing the law firm's name. The request for the issuance of subpoenas for the identified financial records, therefore, pertaining to Carpio lawyers is granted, subject to the remedies in law and/or their legal right to assert a specific claim of privilege over a particular document at the proper time. No generalized blanket invocation of attorney-client privilege should exclude compliance at this time. Therefore, to summarize, the court rules as follows. The request for subpoenas directed to the concerned banking institutions covering the accounts of respondent, Attorney Manasseh Carpio, separately or jointly, the partnership of Carpio lawyers, and the 19 listed corporate entities is granted. The banks are ordered to submit to the clerk of court the documents on July 30, 2026 at 9 a.m. with the attendance of parties and counsels. The request, insofar as it seeks the records pertaining to JTC Group of Companies and Pikimong Philippines Corporation, is denied for failing to establish prima facie relevance. The subpoenas granted shall apply only to peso-denominated accounts relevant to Article 2. Foreign currency deposits are excluded absent the written consent of the respective depositors. The subpoena directed to the Anti-Money Laundering Council covering respondent Attorney Manasseh Carpio separately and jointly with the respondent, the partnership of Carpio lawyers, and the 19 listed corporations and entities is granted. The request insofar as it seeks records pertaining to JTC Group of Companies and Pikimong Philippines Corporation is denied for failing to establish prima facie relevance. Finally, the court is cognizant of the Supreme Court ruling in Almonte v. Vasquez GR 95367, where it stated that a government privilege against disclosure is recognized with respect to state secrets, and it is not amiss to state that even matters of national security have been inquired into in appropriate in-camera proceedings by the court. Therefore, the court ex abundante ad cautela or out of an abundance of caution hereby directs, in order to prevent the unwarranted exposure of sensitive AMLC methodologies and information, to submit the records strictly in camera to the presiding officer through the clerk of court first on July 30, 2026 at 9 a.m., who shall review these documents privately before turning them over to the parties as may be warranted. The parties are directed to be represented by counsel on the aforementioned time and date for the proper inspection, comparison, photocopying, and or marking of these documents as the case may be. So ordered. Moving now on. BR. The impeachment court will now resolve the prosecution's request for the issuance of subpoena dated July 6, 2026, directed to the Commission or Internal Revenue. At the outset, the presiding officer reiterates and adopts by reference the court's citation of applicable rules regarding the issuance of subpoena ducis tecum, which forms an integral part of this order. The foregoing standards are deemed reproduced and shall govern the court's disposition of the present subpoena requests. After examining the records sought, the court finds that the requested documents meet the requirements set forth. They are reasonably described, readily identifiable, and prima facie relevant and material to the allegations under Article 2. However, the court, similarly, requests insofar as it seeks the records of JTC Group of Companies, Philippines Inc., and Pikimong Philippines Corporation. The prosecution failed to establish a prima facie nexus between these entities to either the respondent or to her spouse. The records sought, therefore, do not at this time satisfy the requirement of prima facie relevance under Rule 21 of the Rules of Civil Procedure. The court also resolves the respondent's objection to the requested period from 2007 to 2021. They anchored their opposition on the Supreme Court's pronouncement in Duterte v. HOR that the basis of any charge must be for impeachable acts or omissions committed in relation to their office and during the current term of the impeachable officer. The argument, as stated earlier, fails because first, the documents requested under the subpoena ducis tecum will not be used to allege additional impeachable offenses. This court will not allow it. For the same reasons discussed in the court's earlier order, consistent with the same jurisprudence which are hereby adopted by reference, the court likewise holds that the requested records are sought to establish respondents' financial baseline and capacity only, not to inquire into or prosecute alleged impeachable acts occurring outside the present articles of impeachment. Accordingly, these records are required to establish a factual baseline against which the respondent's assets, financial transactions, and business interests during her present term may be assessed. We are also not without precedent. During the Corona impeachment trial, the Salens, prior to his appointment as Chief Justice in 2010, were presented on the January 18, 2012 hearing of the court. Likewise, evidence and testimony concerning properties and transactions before his appointment as Associate Justice were presented before the court on March 13, 2012. Therefore, the production of records from 2007 to 2021 is therefore allowed and authorized strictly for purposes of establishing a comparative baseline only. They shall not be used as proof of another independent impeachable offense. Their admissibility and evidentiary use shall remain subject to the prosecution establishing their connection to the alleged unexplained wealth during the respondent's present term. The defense's invocation of the Race to the Privacy Act is likewise unavailing. As previously stated, Section 16B of that law expressly states that the right to privacy does not apply when personal information is needed pursuant to a subpoena. Furthermore, Rule 5, Section 22F of its implementing rules expressly permits the processing of sensitive personal information provided to government public authority pursuant to a constitutional or statutory mandate and when necessary for the protection of lawful rights and interests and court proceedings. The court is likewise unconvinced by respondents' argument that the issuance of the subpoena will usurp the authority of the BIR under Section 5 of the NIRC. This court is not determining the tax deficiencies or civil liabilities which remain within the province of the BIR. It is exercising its constitutional mandate to determine public accountability under the Articles of Impeachment. Neither does the pendency of a BIR audit suspend or limit the Senate's exclusive jurisdiction to try impeachment cases. The respondent invokes Section 270 of the National Internal Revenue Code to prevent the production of the requested records. The objection is overruled in part. The Supreme Court expressly ruled in Dipad v. Spouses Olivan, GR 168771, that Section 270, quote, of the NIRC obviously does not address the confidentiality of ITRs. It merely penalizes the unauthorized disclosure of taxpayer information, except as otherwise provided for by law. It does not bar the production of the documents. However, the respondent correctly invokes Section 71 and other provisions of the NIRC, which recognizes only 3 instances in which a taxpayer's records may be opened for inspection. Number 1, upon order of the President or authorization of the President. Number 2, upon the request of a foreign tax authority with the approval of the President. Or number 3, upon the taxpayer's waiver. Nevertheless, the existence of these statutory limitations does not at this stage preclude the issuance of the requested subpoena. The issuance of subpoena is merely a preliminary procedural step and does not by itself authorize the disclosure, inspection, or admission of the requested tax records into evidence. In fact, this issuance is the order that shall set, if at all, things in motion. Upon service, the BIR Commissioner may refuse compliance, very much like what they did with the House, or comply by invoking any of the exceptions under the NIRC as previously mentioned. Without a satisfactory showing of faithful compliance with any of the enumerated exceptions, this court shall not receive any subpoenaed records from the BIR, similar to what was done when the sealed box ordered by this court to be returned to them. There is also a precedent during the 2012 Corona impeachment trial. The Senate issued the subpoena and thereafter awaited the return of the BIR Commissioner. The requested records were produced only after the requisite presidential authorization had been obtained, one of the recognized exceptions under Section 71 of the NIRC. The respondent, however, is not without recourse nor remedy. In the event the requested tax records are lawfully produced pursuant to any of the statutory exceptions, the respondent may at the appropriate stage of the proceedings raise any and all objections concerning their relevance, materiality, authenticity, admissibility, and other evidentiary infirmities. The issuance of subpoena should not be construed as a ruling on the admissibility of the documents ultimately produced. On this basis, the subpoena shall therefore be issued, and we shall await the return of the BIR Commissioner, at which time the court shall take such action as may be deemed necessary and appropriate. Accordingly, in view of the foregoing, the request for the issuance of subpoena directed to Commissioner Carlito Martin R. Mendoza of the BIR is hereby granted. The request insofar as it seeks the records pertaining to JTC Group of Companies, Inc. and Pikimong Philippines Corporation is hereby denied for failure to satisfy the requirement of prima facie evidence. The Commissioner is directed to make the appropriate return to this court in accordance with the law on July 30, 2026 at 9 a.m. before the Clerk of Court. The court shall await the return before taking any further action as may be warranted. The parties are likewise directed to be represented by counsel on the aforementioned time and date for inspection, comparison, photocopying, and or marking as the case may be. So ordered. Senator Judge Alan Cayetano is recognized.
Thank
you were
you
seeking
for that
recognition earlier.
exhaustive ruling, Mr. Presiding Officer. I won't ask you to repeat it. Because you explained both in the caucus and here that there are only 2 motions. There are parts, I'm talking about myself first, but I think some feel the same way. There are some parts that we agree, some parts we disagree. For example, to subpoena the certain records between 2022 to 2026. Then in my case, I agree with the know your client opening balance just for reference so that you have a starting point. So may I suggest that instead of objecting, I don't know if I'm alone or with others, I will not manifest anymore, but may I submit in writing which parts of the ruling I disagree, and if anyone wants to either manifest or submit in writing. But I do have one question to the presiding officer. So you narrated everything. In the page 2 of the request for subpoena for 004, nakalagay, all records filed with, submitted to, or maintained by the BIR for taxable year 2007 to 25, including but not limited to. So sinabi 1, 2, 3, 1 and 2, pero not limited to. The other one, 4, page 4 of the request number 004-2026. Sorry, that's the case number. So the other one is to the, this one's to the anti-money laundering. Nakalagay po sa page 4, and all other relevant documents. So I just like to ask, was your narration exclusive? Because you did say that it's specific enough, but I don't think specific yung all other relevant. The test of if it's definite is that wala nang iisipin yung pinadalan mo ng subpoena. So kung anong nire-rate, yun ang kukunin.
That is a common practice perhaps used by lawyers, but the understanding of the court, and let this be part of the ruling of the court, is that only the documents specifically mentioned
Thank you for that.
and will not include that catch-all phrase, because I doubt too if the banks, the BIR, AMLC, would be able to supply the and such others unless it was specified.
So with the permission of the court, I'll submit my, where I agree and disagree.
Permission granted, and any other senator judge who wish to submit the written explanation in regard to the twin orders may do so. Senator Judge Marcos and Legarda are both raising their hands, so the same applies to them. Submit. Senator Judges Marcos, Legarda, and Villar Camille are manifesting that they will be submitting their manifestations in regard to the twin rulings of the court, and the same is allowed and will be made part of the records. For the information of the court, yes, Senator Judge Pia Cayetano is recognized. What is your pleasure, ma'am?
Mr. Presiding Officer, I'll just make a short manifestation because
The lady may proceed.
Alan's written submission might be so long, it might just be easier for me to make my own manifestation. Para tumawa naman kayo, guys. Sobrang seryoso natin. But it is a serious topic. Very simply, Mr. President, personally, on the issue of the dates, no, for the submission of the, what was it, 2007? Goes back as 2007 to 2026. And the term of the Vice President in question is 2022 to 2026. My humble position is, and I'm cognizant of the case that was cited by the prosecution. I also found that my own research, the presiding officer used it in the justification of the decision, says that you go back to set that baseline. I understand that. Madali naman siyang intindihan. Ang sa akin lang naman, in the interest also of considering the rights of the person under trial, we could have considered starting at 2022, and if there's more than, kung dun pa lang, it already shows that unexplained from 22 to 2026, there may be no reason to go back and at least respect that part of the record. So yun lang naman ang sa akin, kasi hindi naman mahirap na tingnan yung 2022 to 2026. O hindi mo makita yung baseline pero may trend, then dun, saka tayo pupunta doon, di ba? That's our way of showing respect also for the persons who are brought here to trial. But anyway, we submit to the ruling. I just wanted to explain that that could have been a middle ground, Mr. Presiding Officer. Thank you.
Noted and well taken, Senator Judge Pia Cayetano. Chair would now like to take up some administrative matters. We are in receipt of a motion to set conference for the transfer of markings and comparison of video exhibits filed by the prosecution. Since this was received only last Friday, the court was not able to act on it on their requested dates. Court therefore sets this to July 21, tomorrow at 9 a.m. Due notice is given to both parties for this purpose. Likewise, the court is in receipt, the presiding officer rather, as well as the Senate President, of a letter of manifestation signed by Senator Judge Marcoleta, citing a rule in the Arab impeachment trial and wanting his vote to be considered. Chair, the presiding officer in this court will not act on it at this time, but instead, since we will be resuming next week, we'll be referring this matter to the Senate as a legislative body, given that it's the Senate that will be amending the rules to allow participation through a vote. Because apparently, as pointed out by Senator Judge Marcoleta, during the Estrada impeachment trial, a rule was adopted, which we are confirming, that allows the Senate President to provide a mechanism by which a senator who cannot vote under any unavoidable circumstances to cast his vote on any matter. But since this impinges upon the rules of the impeachment court, this matter should properly be taken up by the Senate as a legislative body. And whatever decision the Senate will have as a legislative body, the court shall implement it. But let it be placed on record that personally, once we convene the Senate as a legislative body, I am inclined to agree with the suggestion of Senator Marcoleta, for as long as there is no suspension, according to him. Yes, Senator Judge Cayetano.
I'll not object to that at this point in time. Just as an additional information, I think Senator Estrada elevated to the Supreme Court the denial of the Sandigan Bayan to allow him to attend. But may you also refer my previous manifestation that as a court, we can also communicate whether it's with the Sandigan Bayan or the... But if you're going to say it's going to be to the rules, that's not in conflict. But maybe we can take it up whether in caucus once the Senate convenes.
The point of Senator Judge Allen is well taken. We shall do so at the appropriate time. Now, on other matter, Senator Judge Padilla is recognized. What is your pleasure, sir?
Mahal na tagapamahalang hukom, patungkol po doon sa nangyaring ruling, nais ko lang po sanang magmanifesto.
The gentleman may proceed.
Ginoong tagapangulo at mga kasama, matagal ko na pong isinusulong ang freedom of information dahil ito po ay bumagsak sa aking komite. Ito po ay tunay na kailangan natin. Sapagkat dito po talaga natin mapapatunayan yung sinasabi nating public trust. Pero meron din po kasing napakahalaga yung tinatawag na equal protection of the laws. Sang-ayon po sa Artikulo 3, Section 1 ng ating Konstitusyon, Bill of Rights, ang nagsasabing hindi dapat alisan ng buhay, kalayaan o ari-arian ng sinumang tao ng hindi kaparaanan ng batas. Ni pagkaitan ang sinumang tao ng pantay na pangangalaga ng batas. Ang mga pamantayang ginagamit natin ngayon ay dapat pareho ring ipinatutupad sa lahat ng impeachable officials, anuman ang kanilang pangalan o posisyon. Hindi ko po makakalimutan ang naging pahayag ng dating Senadora Miriam Santiago dito mismo. Siya po ay isang huwes at ginagalang na propesora ng batas. Ang sabi niya, constitutional analysis is a technical field. Ang pagsusuri sa konstitusyon ay hindi isang sining. Isa itong technical na larangan. Hindi po dapat ito ini-interpret ng basta-basta o kailangan may due process. Nung una ko pong narinig kanina na ipaliwanag po ng ating Senator Judge Alan Peter Cayetano, tinanong sa prosecution kung ganito rin ba ang ginawa nila noong may impeachment kay Presidente Bongbong Marcos. Napakalinaw po na ang sagot nila ay hindi naman sila nagtanong. Hindi sila nagsaliksik kung paanong ginagawa nila ngayon sa pangalawang Pangulo. Ang akin po lamang, makatarungan ba na hindi parehas ang trato natin dito? Dapat sana parehas. Kaya po, ang hinihiling ko sa atin, total naman, lahat naman kayo ay sumang-ayon na sa Freedom of Information Bill ko. Hindi pa nga lang nagsasubmit ang House of Representatives. Bakit kung ganito ang pamantayan natin, edi buksan na natin lahat ng bank records natin. Lahat na. Tayong lahat ay buksan na natin. Lahat. Para mapakita sa taong bayan na wala tayong kinikilingan dito. Ito ay oras na para samantalahin natin ang pagkakataong ito na ipasa yung FOI. Kasi kung ganito, na parang meron tayong tinititigan sa tinitingnan, hindi maganda ito para sa taong bayan. Tandaan po natin, pantay-pantay tayo sa harap ng Diyos at ng batas. At hinihingi ko po sa inyo na ilagay sa record ang aking pagtutol sa ruling na ito. Maraming salamat.
For the record, there is a pending bill as well requiring all public officials filing a SAL-N to execute a waiver in favor of relevant government agencies together with their SAL-N, on top and in addition of the FOI bill filed by the Honorable Padilla na tinatalakay din po natin sa ngayon. Before proceeding on one more matter, may I inquire from the lead prosecutor or someone from the panel of prosecutors who their intended witnesses will be for tomorrow and Tuesday? Sorry, tomorrow and Wednesday. Forgive me.
Your Honor, our intended witness for tomorrow is Attorney Melvin Matibag, the NBI Director. And for Wednesday, Your Honor, it will be Marivic Pareja of the Legislative Archive Office of the House of Representatives, Your Honor.
And on Wednesday, the bank officials?
In addition, Your Honor, but considering that we only have Tuesday and Wednesday for trial, but after Marivic Pareja, we will also be presenting the two land bank officials, Your Honor.
Yes, because we issued a subpoena ad testificandum against these two bank officials to attend tomorrow and Wednesday.
Yes, Your Honor.
So for the information of the two bank officials, if they are listening, they may simply attend the Wednesday trial, not the trial tomorrow, although the subpoena indicates tomorrow and Wednesday. Would that be okay, counsel for
Yes,
the
Your Honor.
panel for prosecutors? Lead prosecutor, rather? Yes? So Attorney Melvin Matibag tomorrow, and if at all, Ms. Marivic Pareja and Ms. Marivic Pareja, the two bank officials on Wednesday. Counsel for the respondent, ma'am?
Good afternoon, Your
What is
Honor.
your pleasure, ma'am?
May I be recognized, Your Honor?
Yes, ma'am. This is regarding what matter, ma'am?
Just two administrative matters, Your Honor. The
Please,
first
ma'am.
one with respect to the motion to set conference for the transfer of marking and comparison of video exhibits. We would also like to request that the respondent be allowed to also mark additional documents at the appointed time tomorrow. In effect, we're asking
Also at
the
9
same
o'clock.
latitude. Yes, Your Honor. In fact, some of the documents that we intend to mark tomorrow would be also our copies of some of the listed items in this motion, Your Honor.
Of
And-
course, that motion already made by counsel for respondent is hereby granted. The respondent, in similar fashion to the prosecutor, may also mark
Thank you, Your Honor.
or change the markings or mark any pieces of evidence they wish to do so in order to facilitate the trial. So ordered.
Yes, thank you, Your Honor. And just to place on record the additional marking of evidence and whatever transfer of markings that the prosecution will do tomorrow is without prejudice to Section 3, Administrative Matter Number 2026-001 of this impeachment court with respect to the guidelines for the conduct of the pretrial conference, which explicitly states that the marking is without prejudice to any questions on admissibility, relevance, etc., Your Honor.
That is the understanding, counsel. Yes.
And the second
The
matter,
chair
Your
confirms that.
Second matter, Your Honor, with respect to the earlier ruling given by this court on the two requests for subpoena, Your Honor, the defense requests for certified true copy of that ruling, Your Honor. Thank you.
Chair will address that. It will be included in the journal. However, the journal will have to await the manifestations to be submitted by any senator judge who may agree or disagree with the ruling. So we might not be able to approve the journal tomorrow, although we will do as best as we can. But as soon as the journal is approved, we shall make it available. But the TSN can be made available perhaps by tomorrow.
Thank you, Your Honor. That's all, Your Honor.
Your Honor, may I make a short manifestation with regards to the order of presentation, Your Honor, earlier mentioned by the prosecution?
Of witnesses?
Yes, Your Honor.
Subject to the limitation mentioned by Senator Judge Allen the other week, if you remember.
Yes, Your
Counsel?
Honor, I understand.
The lady may proceed.
We are maintaining the presentation of NBI Director tomorrow, that is Tuesday, July 21. And then following the NBI Director, Your Honor, will be the two land bank managers in the person of Violeta San Constantino of Shaw Branch Manager and Denita Camposano of DepEd Branch Manager. As to the presentation of the Legislative Archive Officer, we will be determining to present her, Your Honor.
So the court recalls or withdraws the earlier statement that the two bank officials may appear on Wednesday. The subpoena stands, therefore, requiring their appearance to respond to the subpoena ad testificandum tomorrow, July 21 and July 22.
We confirm, Your Honor.
So noted. Any other matters that any of the parties wish to raise? There being none, since we did not have a break, trial is hereby adjourned until July 21, Tuesday at 2 p.m.